Thank you, Madam Clerk. Good morning, everyone. This is our August session of the Tennessee Court of Criminal Appeals. My name's Robert Wiedemeyer. On the panel with me are two distinguished jurists. To my right, Judge Robert Holloway from Columbia. To my left, Judge Ross Dyer from Memphis, Tennessee. I live here in Nashville. We have read the briefs on these cases. Most of the lawyers that I see here have been here before and know how we operate. Each side gets 20 minutes. Fairly recently, we started using what I call the light system, which there's a green, red, yellow. You all know what to do. But if you want some rebuttal time, that's what I was getting to. Be sure and ask, and we'll try to set the timer accordingly. Let's see. I can't think of, everybody knows the time limits, and we've got several cases on the docket. So are there any preliminary matters?
No, Your Honor.
All right, I think we're ready. Proceed with calling the first case.
State of Tennessee versus Sarah N. Eakes.
Good morning.
Good morning, Your Honors. I am Pat McNally of the Nashville and Tennessee Bar, and it is my pleasure, and truly my pleasure today, to be here before the panel and also to be here on behalf of Ms. Eakes. In this particularly unique case, and that unique feature of this case is...
Before we get started,
I apologize, Your Honor.
any time for rebuttal because she needs to set the...
Yes. I'll reserve 5 minutes, but I hope rebuttal is not necessary in this particular argument.
All right.
Which goes to my unique nature of this case in that the appellant and the state agree that the trial court did not follow the proper protocols for sentencing or did not consider the proper factors, as well as did not put anything on the record for this court really to review. The only difference we have, perhaps, is that I'm asking this court to go ahead and sentence Ms. Eakes to judicial diversion, and I'll explain a little bit later about why I'm stretching to ask for that particular remedy in this case. I was pleased to see Judge Dyer was on the panel here today because he probably remembers an opinion 3 years ago where I stood up here at the beginning of my statement and I said, when I first got the state's brief, I initially thought someone had made a typographical or had left out a word in it because the state's first issue was that the trial court erred in denying the defendant's motion to suppress, which was what I had said in my brief. And Judge Dyer stopped me and said, Mr. McNally, I had the same thought when I read the brief. That was State versus Nichols, and Your Honor did deliver the opinion in that particular case. The reasons the parties agree that the trial court erred in the sentencing of this case here to where you could actually overcome that very high standard, which is the King standard of there's a presumption of correctness or that short of abuse of discretion, there's a presumption that it was as long as it was reasonable, is that looking at the electroplating case, there simply is nothing in this particular record that explains why the trial court denied the judicial diversion and denied alternative sentencing.
Counsel, let me,
Yes, sir.
since everybody agrees that the trial court did not make the findings it needed to make, and so the real issue we seem to be here today is send it back or us do it.
Correct.
So if you look at all those factors, part of what is in all the, and with the premise that the trial court, for lack of a better way to say, did nothing. Let's just say it that way. I mean, there's fact finding and credibility determinations that need to be made in order to go through this process. Mm-hmm. We don't find facts and we don't make credibility determinations.
I agree.
So how do we get over that hurdle and have us make the findings rather than send it back to the trier of fact with the instructions that you've got to make factual findings, you've got to go through this list, and you need to make a credibility determination on lots of this evidence, whether it's the victim, whether it's the defendant or what, because we can't we don't. You've done this long enough to know we're not sitting there listening to her testify. We're not listening. How do you get us past that hurdle?
I would say that, and I'm mindful of Your Honor's opinion in the Pitts case too, that just recently came out in July, which was after everybody had filed their briefs here. But what I would say is that you can look at the entire record in this case, including when the case was remanded back to the trial court for consideration of whether an appellate bond should be, whether Ms. Eakes should be released on an appellate bond. This has a bit of a tortuous history. This case is 10 years old now, and this judge, the trial judge that initially had the case, sentenced her to 18 months. An appeal was taken. The appeal bond was denied. Ms. Eakes was very fortunate this court remanded it back again for determination of whether she should remain on the same bond should be increased, or no bond. And there was a hearing there, and it's contained in Exhibit number 7, all the information that was in there, including the successor trial judge's order finding that this information was relevant and credible to where the trial court, the successor trial court, allowed her to stay out on the same bond that she was originally on, the original $25,000 bond. So that goes to the trial court finding credible the evidence that was presented on her behalf, which actually was sentencing evidence. It included letters from her employers where she had been employed at Sonic since age 16. Well, one of them said that he would entrust her with the keys to his $1 million business, that she was a very good mother to her child of 10 years of age. And Judge Dyer, getting right to the point, none of the information that is in this record here is disputed by anyone. Amanda, I apologize, I need to check her last name again. But one of the witnesses testified, talked about how she allowed the child to stay, allowed Miss Eakes to babysit her child. And she talked about what a good parent she was, how they attended baseball games together and everything. On top of that, we have the evidence that shows that she's amenable to treatment. She attended Child Protective Services classes on parenting. She abided by every rule and regulation for the 8 years that the case was pending before she went up to sentencing hearing. What I'm getting to is there's no there's no credibility, there's no dispute about the evidence that is in the record before this court. I do admit it's a bit of a challenge. I am stretching, and it's a bit of a challenge because I'm asking this court to look at the entire record that's now before the court. The sentencing hearing, which didn't have a lot to it. It was argument, along with the pre-sentence report and the strong arm report, which there was no dispute that the strong arm report showed that she was amenable to treatment and she was not likely to ever repeat an offense again. But then you have the hearing that occurred on the remand, and that's in the record as well. And there's no dispute about all the evidence that was presented. And that's why I'm saying that's why we have stretched in our reply and said, based on the record before this court, you can make a finding that judicial diversion is appropriate in this case.
Following up on Judge Dyer, what you're saying, he pointed out fact-finding. You're saying all the facts have been found and are not in dispute.
Correct.
And credibility finding, you're saying all the witnesses who have testified and there's no credibility issues. They're either been found to be credible witnesses by the trial court or not, but there's no credibility determinations for a trial court would need to make, observing the witness face to face, that type of thing.
Correct. And reading the transcripts of that remand hearing, you can see that the state did not really try to impeach the witnesses for their credibility, just tried to point out the seriousness of the offense. And that's in there. I mean, the evidence is in there about this child and the tragedy that occurred to this child. And one of the reasons I'm asking this court to go ahead and sentence Ms. Eakes to judicial diversion, should the court determine that it's appropriate, is because, as I said, this has been going on 10 years. And, truthfully, I have a lot of faith in the successor judge about what she would do at sentencing, based upon the fact that she left my client stay on a $25,000 bond that was originally there. Didn't ask to increase it at all. But my client is has spent a significant amount of money. She's been up here twice now. It's been 10 years. I would really like to bring the legal proceedings to a closure and reduce her anxiety and her financial burden. While her family has money to hire attorneys, as it's pointed out, she's working at Sonic, raising a 10-year-old child and babysitting on the side. There is that concept that this court has, maybe you don't find it in law books, but it's called the doctrine of finality. It helps to have some point when things come to a closure. And I would really like to be able to tell Ms. Eakes that she was successful at this level of the proceedings and that the case is over. Or over in terms that she's still got the obligation to finish up her judicial diversion, whatever the term may be. But it would be just so beneficial for her to be able to put this to rest and know, here's what I've got to do for the next year, 2 years, whatever this court would determine. There's a public interest in that. There's obviously a private interest for my client, but there's also a public interest.
Let me ask you this question.
Yes, sir.
Since you bring up finality, let's say we agree with you and we place her on diversion. Would it be your position that it's 18 months of diversion, or are you going to try to also argue that, well, we've been sitting around and she's behaved herself, and so we can somehow mess with that number too?
This court is not bound by the 18 months, and I do not look a gift horse in the mouth, and Ms. Eakes would not look a gift horse in the mouth. And I'm not calling the court a gift horse by any, but it
called worse, I'm sure.
I can promise you holiday.
No. Certainly do not mean any disrespect, but that metaphor is perfect for this. You know, once given a gift, don't go looking to see how old it is. And that what I'm saying is we're not going to look and see how long it is. She'll comply. She's been complying, but this court has the discretion to do. I would also be mindful, she spent 40-plus days in jail waiting for the remand to come back, and fortunately, again, this court released her. When it was remanded, they released her, and then said for the trial court to make a determination. I'm not answering your question directly. We'll take whatever we can get
I
to the truth.
Your answer.
You know, I like that expression that lightning never strikes twice, but I'm really grateful today that lightning struck twice here for Ms. Eakes and my previous client. In 40-some plus years, this is only the second time where the state has agreed almost completely on what our position's been. I will say one other thing. I learned a lesson from the state. Their brief is half the size of mine. They got it done. They said the same information, made just about the same arguments in 15 pages. It took me 30. The only additional part I had there was putting my knee pads on and begging the court to go ahead and sentence Ms. Eakes to judicial diversion. But they have taught me again that the word brief means brief. Thank you, Your Honors.
I got one question.
Yes,
Does
sir.
the record explain why it took, 7 years from the date of the indictment to the time she was sentenced?
Mr. Todd, who was the attorney that represented Ms. Eakes at the trial level, along with attorney Katie Hagan, I believe at the sentencing hearing he addressed that. I can tell the court, and the only reason I would know it is because it's in the record, but the reason is the case was moving very slowly. There were a number of successor assistant district attorneys assigned to the case. And then at one point, COVID came into play a little bit. But you know, it turned out to be beneficial for Ms. Eakes, because initially, the medical person who treated the child said this looked like abused, and they changed their opinion. And that's what flipped this case around to a neglect case and allowed them to plead out to the Class E misdemeanor, Class E felony of child neglect. But it was, you know, most of it was just waiting and waiting and waiting. And then finally, when the state went to talk to their experts again, they said, you know, we were wrong initially. Thank you, gentlemen.
Thank you, Mr. McNally. Morning, General Ball.
Good morning. May it please the court, Ben Ball on behalf of the state. I appreciate Mr. McNally's comments about the state's brief, and in fairness, it's a lot easier to be brief when you're essentially saying me too. Here, the state concedes that the trial court did not make sufficient findings as to the electroplating factors to sustain this denial of judicial aversion. However, where we differ is we ask this court to remand to the trial court to revisit this instead of reviewing this de novo. And the reason we ask that is the same as the reason we concede. There's simply a real dearth of findings here by the trial court. They are very brief, and it's the state's position that it is insufficient for this court to review it. We don't have findings about credibility, for one, and that's largely important here. There's simply not enough for this court to go on. And if there were, I would be arguing strenuously for this court to review this de novo and deny judicial aversion. But unfortunately, the trial court did not.
If there are no findings as to credibility, why can't we just assume, and I know that's a bad thing for a court to do, that the trial court treated everybody as credible?
I think that would be difficult here because I think there would be some credibility findings that would need to be made that are not even alluded to by the trial court because the trial court doesn't weigh in on those issues. So say amenability to correction, which I think everyone agrees is probably the most important electroplating factor. We have a defendant here who admitted to using marijuana on a daily basis. And her excuse was essentially, I was stressed. We don't have any findings about that. We don't know how the court weighed that and how it, to what degree it accredited her testimony and her explanation for it. So I would urge this court to remand to the trial court for a reevaluation. And if there are no further questions, I won't belabor this court's time, and I would urge you to remand to the trial court. Thank you, Your Honors.
Thank you, General. Mr. McNally, you want to second? All right. Thank you. The briefs were excellent by both sides, and we'll take it under advisement, try to get this an opinion out as soon as possible. All right, next case, please.